What are the new H-1B regulations? What do they mean, and are they here to stay? That's what we're talking about at today's Live at Lunch. My name is Emily Sumner with Sumner Immigration Law, and I'm so glad that you have joined us, whether you're joining us live or whether you're catching the replay. If you have questions about this content or other immigration-related questions, family-based, employment-based immigration questions, please drop those in the comments and we will respond to them as we can. So in late December, or rather in December, late 2024, in December 2024, USCIS dropped some new regulations that affect the H-1B visa program. So the question is, what do they mean? What do they change? And what will happen to them in the Trump administration? Let's back up a minute before we delve into the details of the new regulations and talk about what a regulation is versus the statute. The statute is the immigration law. It is written by and approved by Congress and then signed into law by the president. And that forms the foundation of the immigration rules that we have in place. The regulations are supposedly based on the statute, and they are created by approved. There's typically an administrative procedure per the Administrative Procedures Act. There's typically a notice and comment period, but they are implemented by the agencies that are responsible for implementing the statute, basically. So in this case, USCIS is the agency, or Department of Homeland Security is the agency that has come up with these regulations. So there are two sets of regulations. One is one that came out on December 13th, and that basically made permanent. It's not directly related to H-1Bs, but it made permanent the automatic extension of certain EADs. So EADs are employment authorization documents, also known as work permits. Typically, you file the form I-765 in order to apply for this work permit, and it's always based on some other type of filing. You can't just apply for a work permit. That would be easy. Sounds easy to do, but anyway, it's based on something else, like, for example, certain spouses of H-1B visa holders can apply for an EAD. Other dependent spouses, for example, they don't necessarily need an EAD anymore, but the spouse of an L1 visa holder, an E2 visa holder, you can apply for an EAD based on asylum, TPS, DACA, any number of different classifications. Anyway, this rule has made permanent. It was a temporary rule previously, but now the rule is permanent that certain types of EADs, not all, but certain types of EADs are now automatically extended for up to 540 days beyond the expiration date listed on the current EAD, as long as the person holding that EAD has timely filed to renew in that same classification. So timely filed means you have to have filed before the current EAD expires, and same classification, of course, means it's the same. It's based on the same classification. So for example, if you have an H4 EAD, you've applied to extend to renew the H4 EAD, you're not changing to a different type of EAD. So that is that rule that came out in December. Also part of that, the H-1B, we'll talk about this more in just a minute, but the H-1B cap gap has been extended until April 1st, which is huge. Going back to the EAD automatic extensions, keep in mind that it's only valid, it only applies to certain classifications, to certain types of EADs. It does not apply across the board. So if you are, I get questions all the time from our corporate clients, our HR representatives as part of our corporate clients, or just small business owners saying, hey, I have this EAD that is expired. Can you help me determine if it is actually valid? So in other words, you can't just look necessarily at the EAD, see that it's expired and say, oh, no, that doesn't work anymore. You have to check to see if it's subject to some sort of extension, automatic extension, including these that are subject to the 540-day extension. And there's a list. There's a link that I'll try to remember to link in the comments here, but I'm always happy to answer questions as well. I help employers with that type of question all the time. So we're happy to help with that. The second set of regulations that came out in December is regarding the H-1B visa classification. It's called they call it the modernization of the H-1B visa classification. And I am going to refer to notes here that might fall off my computer. because there are a lot of changes. It was hundreds, the regulation was hundreds of pages long. I have not read every single page of the regulation. What we have here, what we're talking about today, is a very, very high level summary that is not going to cover every detail and is not going to cover every aspect of the regulation. So know that there were a lot of changes, and we're just kind of scratching the surface here to give you an idea of what's been implemented. And then we will also talk about what to expect and the Trump administration, specifically in terms of this regulation, these regulatory changes. So one change is there's a new form, a new H-1B form, a new I-129 form that you have to use starting January 17th, which I cannot believe it, but it's in 10 days, 10 days from now. So you have to use that new form. There's some changes regarding specialty occupation, regarding the definition of specialty occupation that I actually think are reasonable changes. Things like the regulations say that they will consider the beneficiary's actual course of study rather than just the title of the degree. That's something that we've argued for a long time when we've had either requests for evidence about specialty occupation or just proactively explaining how a person's degree, a client's degree, is related to the position. We've long argued that, like, look at the transcript. These are the relevant courses. We've even made tables of the courses and how that's relevant to the job duties. So I'm glad to see this in the regulation. Other changes relating to specialty occupation. I don't see this as a huge change necessarily from standard practice, fortunately. But, in general, the H-1B has to be a position that requires a minimum of a bachelor's degree in a specific field of study. And they're saying that it has to be a directly related degree, which is defined as a degree having a logical connection between the required degree and the duties of the position. So again, that's something that we have long argued. I don't see it as a big change, but it's nice to see it in the regulations. In addition, this is going to sound silly, but in addition, if the petitioner is trying to show that the position is specialty occupation because a bachelor's degree in a specific field of study is normally the minimum requirement, the regulations have defined the word normally. And I'm laughing, smiling here because there have been so many times over the past 19 plus years that I've been practicing that we've actually printed out the definition of normally from, like, the Oxford Dictionary or whatever online dictionary to define the word normal, because the word normal does not mean always. It does not mean 100% of the time. So we've had to argue that it doesn't mean it's sometimes required. It doesn't mean that it's often required. It means, or not necessarily that it's sometimes required, it means that it's usual, typical, common, or routine. So again, it doesn't, it's kind of in this sweet spot. It doesn't mean it's this particular degree is always 100% of the time required, but it also doesn't mean that the employer will accept just any degree in any field of study. So I think that's a reasonable change. And then another change within specialty occupation, or not really a change, I have kind of assumed this to be the case for a long time. Again, glad to see it in the regulation. But if there are multiple fields of study that are acceptable, you have to show why each of those fields of study are acceptable and directly related to the proffered position. Again, that's something that we've done for a long time as well. Sometimes there are positions that will require a degree in the field of study A or B. For example, a clinical data manager sometimes our clients will say, yes, our clinical data manager, for that position, we absolutely require a minimum of a bachelor's degree. It can be a degree in either statistics or pharmacy. And those seem like two different degrees types. And, on the face of them, they are. But once we get down to explaining why both of those are directly related to the position, the petitions have been approved. So again, it's kind of nice to see that in the regulation. It seems logical to me. Other changes, apart from specialty occupation, are H-1B cap exemptions. We won't get into this too much, but the rule changes the requirement that a nonprofit research organization or government organization it used to say, the reg used to say that it has to be primarily engaged in research or have a primary mission to perform research. Now it has to be a fundamental activity rather than primarily engaged. And then it also clarifies work performed at a qualifying institution can include working remotely, yay 21st century, telework, offsite work, that type of thing. The definition of employment and third-party client sites, that's, I think, going to be key for not all, but a lot of types of filings. So they eliminated the employer-employee relationship requirement and replaced it with the requirement that the petitioner have a bona fide job offer for the beneficiary to work. And that, of course, again, includes telework, remote work, or other offsite work, including working from home. The definition of the employer, this is important as well. The definition of a U.S. employer has been expanded to include those that have a legal presence in the U.S., are open to service of process, which means receiving notices for being sued, and to have a U.S. tax ID number. That is critically important because it opens the doorway for owner beneficiaries to petition for themselves. That has been possible sometimes previously, but it has not been as easy to do because you've still had to show an employer-employee relationship. So in theory, that will be easier to do for people to self-petition for their own companies. We'll have to see how it plays out in reality, and we'll talk about that a bit more in just a minute. They also talk about situations where a person is staffed to a third party, like a client site, for example. If they are like integrated into it's a little bit of a distinction. If they're like integrated into the hierarchy at the client site, then it's really the third party client who determines what the requirement is for the degree requirement for the position. Whereas if they're working on providing services or just like, for example, working on a discrete project, but they're not integrated into the staffing of the client site, then it's the employer who makes that decision about what is the actual requirement, degree requirement, and field of study and all of that. That's a really nuanced, I think, difference between those two. All right. Site visits. This is going to be huge, I think, in the Trump administration. We've talked before a bit about what to expect in the Trump administration, and compliance, I think, is going to be at the top of their list in terms of, at least in terms of employment-based immigration. So the rule expands the authority and compliance requirements for H-1B site inspections. So that means that USCIS is authorized to conduct site visits at the petitioner's worksite, at neutral locations, and other places where the H-1B work will be performed, including third-party customer locations. So third-party client sites, or even at a person's home. That's super fun, right? If you're working from home and then you get a site visit, but they're saying that this is possible. And they're also saying that if USCIS is unable to verify facts and information, then USCIS can deny or revoke a petition. So compliance is going to be huge. Moving to a different topic within the regulation, amended petitions. It's in the regulation as to when an amended petition is required. Essentially codifying or putting into the regulation the matter semio solutions, which is helpful to have in the regulations. And it says when incorporates the Department of Labor rules, which is interesting because Department of Labor is a different agency and they can't like make a regulation for a different agency. But anyway, they incorporated the Department of Labor's own regulations into these regulations about when a new LCA is and is not necessary, which is helpful. That's a common question that we get all the time. They codified deference, the deference policy, meaning that USCIS will generally defer to previous decisions on cases unless there's a significant change. We'll see what happens there. And then the cap gap extension is the last thing, well, second to last thing that I want to talk about. So H-1B cap gap, we probably need to do a separate video on. The H-1B cap gap refers to the situation where a person is, let's say a foreign national is working on OPT, and they have been selected in the H-1B lottery, and their OPT ends before October 1st. So know that a new H-1B petition cannot start H-1B status until October 1st of that year. So let's say that you have a foreign national employee whose OPT is going to end on July 1st, just making this up, of 2025. Then per the current regulations, or the regulations that have been in place until now, the cap gap would apply, meaning that they are, assuming they meet certain conditions, and there are certain conditions that they have to meet, that they would be able to continue working pursuant to H-1B cap gap until September 30th. That means if the H-1B petition was not approved before September 30th, let's say, for example, 2025, using this year as an example, then they would either have to stop working or they would have to, before that date, upgrade to premium processing to make sure they have an approval before September 30th. So there's not an interruption in their work authorization. This rule changes it. It's amazing. So that cap gap is extended until April 1st of the following year. So let's take this year as an example. So the H-1B lottery opens in March. Let's say you're selected, you file in April, and your OPT or your employee's OPT ends at July 1st of 2025. Under the previous rule, that H-1B cap gap would last until September 30th. Now it will last until April 1st of 2026, which is fantastic. That's a huge change that I'm really hoping will stay. So that is a great transition. Now let's segue into what will happen in the Trump administration. So we have these changes, a lot of which seem either neutral or positive, or at least a continuation of, or like a codification, putting into the regulations kind of the practices that we've seen the past several years. So what's going to happen in the Trump administration? Nobody knows for sure. Because these changes are in the regulation, it is going to be harder to change these than if they were just like a written policy. If USCIS had issued a policy memo and said, hey, we're going to take this, this is the trend, or this is the policy, the procedure that we're going to follow, it would be easier to change that than it is now that they're in the regulation. That does not mean that the regulation cannot be changed. Regulations change all the time, as you can see from this regulation and previous regulations. So they change all the time, but there is, in general, a process that you have to go through to change regulations. And I think it'll be harder to change. But we'll have to see as far as what the Trump administration's priority is in terms of immigration and making changes to these particular regulations and other regulations that we have in place. So that's a non-answer to the question of what's going to happen. We'll have to wait and see, but we will keep you posted. And we will also keep you posted on trends that we're seeing, processing trends that we're seeing. A lot of times, even though there's not a change in the regulation, there is a practical kind of on the ground change that you only know about from filing lots and lots and lots of these petitions and talking to other people who do the same. So I hope that you have found this information helpful. We will be back next week for Live at Lunch on Tuesday at noon Eastern. Again, my name is Emily Sumner with Sumner Immigration Law. We serve clients all over the United States and from around the world, helping clients with employment-based and family-based immigration matters. If you found this information helpful, I hope that you will subscribe to our channel and share this video with a friend or colleague. Until next time, my name is Emily Sumner.